So we're studying the Bill of Rights and specifically the concept of due process. This video is the third part of a series of 4 devoted to due process, and this video is devoted specifically to the 6th Amendment. If you think if you've watched the first 2 videos on due process and you think you pretty much understand how wide-ranging the concept is and how it applies to different amendments and different stages of the legal process, you can probably skip the next 10 slides or so, about the next 6 minutes of the video. It might be helpful to have a copy of the Bill of Rights with you. It might be helpful to have this 23-page packet full of Supreme Court case summaries that you've been provided with. It might be helpful to you to have this one-pager that you've been provided with that lays out the entire concept of due process from beginning to end. It's really good to have that understanding of due process, so you don't just focus on the words due process that happen to be in the Fifth Amendment, and you understand that the concept of due process is scattered across several amendments and other places in the Constitution, and isn't just associated with the trial, but also concepts before and after the trial. And it would also be helpful to have this page of due process related Supreme Court case decisions that you've also been provided with. The phrase due process refers to all of the rights that are due to you. That means you get them. The government is required to respect these rights that are necessary for you during any sort of government process that affects you. Any sort of process means procedures or steps that the government takes when it makes decisions about you. And usually when you're talking about due process, you're talking about the legal or the criminal process. The government is deciding whether or not to lock you up or punish you in some way. So maybe one way to summarize due process is all of the necessary steps that government must take in order to punish someone, or in other words, all of the rights you must receive in order to have a fair trial. For this reason, sometimes your due process rights will also be referred to as the rights of the accused. And as the chart that you've been given tries to illustrate, your rights as an accused person, your rights as a citizen, your due process rights begin well before a trial. They exist before the trial, they exist during the trial, and after the trial. They are referred to in several places in the Constitution and by several amendments in several places in the Bill of Rights. For example, if you refer to the due process rights and related cases handouts you've been given, you'll see that your due process rights restrict the behavior of the government even before you are arrested, because in order to arrest you, the government must have something called probable cause. Probable cause based on evidence it has already gathered. The gathering of that evidence is pretty much the rules for gathering evidence are laid out in the Fourth Amendment, where it says you have freedom from an unreasonable search and seizure. So the government must conduct its searches or seizures of property or evidence in a legal manner consistent with the Fourth Amendment. Those cases off to the right there, don't worry about those. We'll discuss those later in the video. Your due process rights are also in effect after you've been arrested or taken into custody and before your trial begins. For example, in the Constitution itself, it says the government cannot arbitrarily detain you or indefinitely detain you without any specific charge. That's called your privilege of the writ of habeas corpus, and that's in the Constitution itself, Article 1, Section 9. The Fifth Amendment, the Sixth Amendment, the Eighth Amendment all have something to say about your rights and the limitations on the government's power in between being taken into custody and having your trial. Notice a couple cases over there on the right. We'll talk about those in later videos. During your trial, you have additional due process protections. Most of them are found in the Sixth Amendment. You can read them over here or on your handout. But there's a little bit of the Fourth Amendment protecting you during the trial, and a little bit of the Fifth Amendment protecting you during the trial as well. The only case in this video that appears over on the right is Mapp versus Ohio. It is not required by the College Board. However, the concept that's associated with Mapp versus Ohio, the exclusionary rule, is an important concept, frequently appears on AP exams, and will be discussed in this video. After your trial, your due process rights continue to protect you from government misbehavior, let's say. Most of it is covered by the Eighth Amendment, but there's still a little bit of Fifth Amendment protecting you there too. There are a couple cases there mentioned that'll come up in the Eighth Amendment video. And then just to make sure you get a complete picture of the idea of due process, there are things in the Constitution and in the Fifth Amendment that govern government behavior kind of completely outside the legal system. We call those extrajudicial prohibitions. You've already learned that the government cannot just pass a law declaring you to be guilty. That's a bill of attainder. The government cannot pass a law that says what you've done that was legal in the past is now illegal and you can be punished for. And then there's another little bit of the Fifth Amendment that is helpful also. So as you can see, different amendments kick in at different points in the process. The concept of due process is scattered all over the Constitution and the Bill of Rights. So now let's get on with the rest of the video.
In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
The first word that needs to be explained in the Sixth Amendment is the word speedy. Now, you may remember that your habeas corpus protection that's described elsewhere in the Constitution, specifically Article 1, Section 9, I believe, says that the government cannot detain you arbitrarily or indefinitely. So exactly how quickly must the government charge you and give you a trial? These issues have mostly been settled by this point in our history. I believe there's a federal law that says that the target for a trial would be within 70 days of having been charged. State laws generally have about the same time frame. Every once in a while you hear about an exception to the time limits that are defined by law, but generally speaking, this part of the Sixth Amendment has been settled, and there aren't many controversies about it or Supreme Court cases that we need to know. The Sixth Amendment also specifies that criminal trials shall be public. That means open to the public. This is echoing some language in Article 3 of the Constitution, and I just want to take this opportunity to point out that this is kind of a check on the power of the government held by the people themselves. To stop, secret trials, trials held in secret, obviously the government could pull all sorts of shenanigans and just to make sure that somebody gets put in jail. Opening trials to the public in the Constitution means that everything the government does is open to scrutiny on the part of the public to make sure that all the rules are followed. The public also includes the media. So I just want to take this opportunity to point out a couple concepts that you should be familiar with already. Popular sovereignty, the people have ultimate authority, and the role of the media called the watchdog role, to bring to the public's attention any illegal or sketchy activities undertaken by the government. Impartial jury of the state and district wherein the crime shall have been committed. The key word is impartial. The composition of juries, that is to say, who is actually on juries, and the powers that they have been a frequent issue in our legal system over the years, and we will be looking at a couple court cases about that issue in the rest of the video. The Sixth Amendment further requires that the accused person be informed of the nature and cause of the accusation. In other words, you get to know what you're being charged with. That might seem pretty basic to you, but I would point out that there are countries around the world with legal systems in which that right does not necessarily exist. People are put on trial without even knowing what they're being charged with, which of course makes it impossible to defend yourself. So if you live in America, be glad that the Sixth Amendment is there, and that that very basic right of knowing what you're being charged with is guaranteed to you by the Sixth Amendment. I would just point out that this is kind of an additional spelling out or fleshing out of your habeas corpus privilege, which says that the government can't detain you arbitrarily. That means for no reason. The Sixth Amendment comes right out and says they have to tell you why you're being held. Confronted with the witnesses against you, that means in open court you have the right to hear and see what witnesses are saying about you, and to hear and see what other evidence is being presented against you. Pretty basic right, again, but we go to the trouble in America to actually spell it out in the Sixth Amendment. The next phrase in the Sixth Amendment that needs to be explained is this part about compulsory process for obtaining witnesses in your favor. So not only can the government bring forth witnesses and evidence that tries to prove you're guilty to the jury, you have the right under the Sixth Amendment to bring forth your own witnesses. And the compulsory process part of that phrase means that the government, even though the government's the one trying to put you in jail, has to use its power if you request it, to force witnesses to come forward and give their testimony if they're reluctant to. The piece of paper that says someone has to appear in court and testify is called a subpoena, kind of spelled funny, but if you look at it closely, subpoena, it means under penalty. It's Latin for under penalty, which means if you are subpoenaed, you are under penalty if you don't show up. So it's how the government can force people to come into court and testify. And the Sixth Amendment says you can ask the government to use that power to make sure witnesses come and testify in your favor. And then finally, have the assistance of counsel. Counsel is an attorney. Counsel is a lawyer. This is the part of the Sixth Amendment that says you have the right to have a lawyer. Just a little heads up, this issue comes up over and over again, especially in this video, because there have been lots of cases about this particular right. And one of the cases that will come up in this video, you must know for the AP exam, because the College Board has said it's a required case. So keep your eye out for that. Speaking of which, this slide and the next two slides are all about the right to have an attorney. In 1932, in Powell versus Alabama, the Supreme Court said you have a right to a lawyer in a capital felony case. Remember, capital means a crime for which the possible punishment is the loss of life or the death penalty. The Supreme Court said here that you have a right to a lawyer in such cases, and you may recognize the name Powell versus Alabama because it's a famous incorporation case in which the right to have a lawyer was incorporated and applied to the states by the Supreme Court. But only that decision was limited to a certain type of criminal case. In 1938, this is a federal case, Johnson versus Zerbst. Gotta love that name, a good German name. Established the right of the poor to be provided with an attorney in any federal criminal case. So if you were too poor to afford an attorney in a federal case, in a federal criminal case, the Supreme Court in 1938 said the government has to provide you a lawyer, which laid the groundwork for 1963. Gideon versus Wainwright. Here's your required case. You didn't have to wait too long. The College Board says you must know this case. It's a very famous case, one of the most famous cases in American legal history. I'll let you read the summary of it in your 23 case summary packet. But basically, Gideon was a poor criminal, committed a felony, asked for a lawyer at his trial in Florida, and because this decision didn't exist yet, the judge in his case thought he was within his rights, within his power to say, no, you don't get a lawyer. So Gideon had to defend himself. Of course, he was convicted. And he very famously, there's books and movies about this guy. Not that he's all that much of a hero, but still famous in our legal system because sitting in his jail cell, he did his own research. He used the prison library to figure out how to do it, and he appealed his own case all the way up to the Supreme Court. And the Supreme Court did assign him a lawyer, and he actually ended up winning his case. And the Supreme Court said basically, if you're too poor to afford a lawyer in a state criminal proceeding, the state has to provide you a lawyer. Those lawyers are known as public defenders, and it's just part of American life now. Gideon himself got a retrial, and I believe he was found innocent. And in state courts all over the country, there were, in a lot of states, they decided just not to retry a lot of cases where people like Gideon had gotten unfair trials because they weren't allowed to have a lawyer. So thousands of people across the country went free because their due process rights had been violated. Anyway, it's a big case. The College Board says you got to know it. Make sure you study that summary in that packet, or look it up. It's very easy to find information about Gideon versus Wainwright. In the next case, the defendant, Esteban Escobedo, must have been reading the headlines or paying attention in government class, because when he was arrested in Illinois, he must have heard about the Gideon case, and when the police started questioning him, one of the first things he did was ask for a lawyer. He knew he had the right to a lawyer, and he asked for a lawyer during questioning. Now, this is well before trial. This is just after having been arrested. But at that time, police were accustomed to just interrogating, and they didn't feel it was not established law yet that they had to provide you with a lawyer, because the Gideon case was about at the trial. Escobedo had just been arrested and was just being questioned. He asked for a lawyer at that point. The police refused. Excuse me. And when his case, he was eventually convicted, and his lawyer, when he eventually got a lawyer, it was appealed to the Supreme Court. And the Supreme Court said, yeah, well, the right to an attorney, even though the Sixth Amendment is vague on this, on the timing of it, the Supreme Court said, you have the right to a lawyer before the trial, during questioning. I just want to bring up another case that we've already discussed in a previous video. The Escobedo case was an important little stepping stone on the way to Miranda. Escobedo knew he had the right to a lawyer and asked for one, and the police said no, and the Supreme Court said that was wrong. In the Miranda case that we covered in the last video, he was unaware that he had the right to a lawyer and never asked for one. And so the Supreme Court in his case went further with that right to a lawyer and said, you have to be the police have to inform you that you have that right in case you don't know it. In 1972, Argersinger versus Hamlin, this took the Gideon decision and took it even further. Gideon had been accused of a felony. Remember that a felony is a crime for which the possible penalty is a year or more in jail. A lesser crime is called a misdemeanor. Argersinger was charged with a misdemeanor, and at that point in our history, it was not legally required that such defendants be provided counsel. This case, like I said, took the Gideon case a step further and said, even if you're only accused of a misdemeanor, not a felony, you still must be provided a counsel in case you can't afford one. And just real quickly, one more slide on the right to counsel. A couple more recent or modern cases in Ropia. The Supreme Court said that if a lawyer makes some obvious mistakes, that could be the grounds for a mistrial and a retrial. And then in 2008, in the Rothgary case, the Supreme Court said that if someone cannot afford an attorney, it has already been established that they have the right to ask for one. That the government has to provide one, but case was about the timing of it. Exactly when does that lawyer have to be provided? And in this case, the Supreme Court said at the moment of the very first encounter between the defendant and a judge, the very first initial hearing in a legal case, that is when the right to an attorney kicks in, and that's when a defendant must be provided a lawyer by the government. So the 1954 Hernandez versus Texas case is a little exciting because after years of teaching it, it finally showed up on an AP exam last year, or 2019. It turns out in Texas in the 1950s, there had been in place a set of procedures in terms of deciding who gets to be on a jury and who doesn't. These procedures basically, for all intents and purposes, excluded Mexican Americans from serving on juries in Texas in criminal trials. And Hernandez lost his case and appealed on the basis that the jury was unconstitutionally constructed by having Mexican Americans excluded from juries. When it got to the Supreme Court, they agreed and said that his trial was not fair because the jury was not impartial because of the actions that the state of Texas was taking with regard to excluding Mexican Americans from juries. Technically, it's a 14th Amendment Equal Protection Clause case. We'll get to that when we get to civil rights. But because the decision in this case referred over and over to the necessity of having an impartial jury, even though it didn't specifically mention the Sixth Amendment, it really was about this important Sixth Amendment right of having an impartial jury. And again, it does appear on the 2019 AP exam, the SCOTUS comparison question, the FRQ that year asked you to compare the Hernandez case versus Brown. Now, that'll never happen again, but it's kind of interesting that some of these cases could easily pop up on a test because they're similar to or relevant in some way to a case that is required. So another reminder, please pay attention. And finally, both of these cases involve what are called peremptory challenges during jury selection. It may interest you to know a little bit about how juries are formed. Basically, you have a courthouse that's continually having trials, and ahead of time, the administrative people that work in the courthouses, they send out summonses to ordinary citizens requiring you to show up for jury duty. But it's not guaranteed that you'll end up on a jury because they call way more people in than they're actually ever going to need. A typical jury is 12, but they call in hundreds because they don't know exactly, how many trials there are going to be and blah, 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 how long they're going to last, blah, blah, blah. And anyway, for a typical jury, a typical trial, even though they only need 12, they might call in 50 or 100 people. And the attorneys for the two sides, for the prosecution and for the defense, are able to disqualify people based on certain reasons. If they give a specific reason, that's one type of challenge. Like, for example, if someone in the jury pool is a lawyer, well, no lawyer wants a lawyer on the jury, so they're going to exclude somebody for that. Or if you happen to know the defendant or related to the defendant, or you've been accused of a crime similar to what the defendant's being accused of, those are reasons for which you would be excluded from a jury for cause. A peremptory challenge is when one of the attorneys in the case can just say, you're off the jury, and they don't have to explain why. Now, this is a little discouraging because this is only 1986 and 1994, but it had been common practice in a lot of places that if an attorney didn't want, let's say, black people on the jury or women on the jury, they would use their peremptory challenges to remove people they didn't want on the jury, and they didn't have to explain it to anybody or justify it to anybody. Well, finally, in 1986, the Batson case was about peremptory challenges based on race, And then in 1994, was about the Jeb case was about peremptory challenges based on sex. And the Supreme Court said you can't do that anymore. Not that long ago, but a necessary upgrade to our legal system. I think you'll agree. Your due process rights, or your rights of the accused, are scattered all over the Constitution and the Bill of Rights, but a whole bunch of them are located in the Sixth Amendment. Basically, almost everything you would need to have a fair trial is located. All the rights that you need to have a fair trial are in the Sixth Amendment somewhere. The notions of a trial being speedy, public, having an impartial jury, the defendant knowing that having the right to know the charges against him, calling and confronting witnesses, the right to an attorney. Those are all key components of a fair trial, and they are all found in the Sixth Amendment. Some of these have been pretty easy for the courts to decide over the years because all these words are fairly vague and have to be decided in detail what they mean, either by law or by court interpretation. The Supreme Court has had to decide lots of these details over the years, especially when it comes to jury impartiality and the right to an attorney in several different situations. And finally, make sure you catch the next due process video, which will be devoted to the Eighth Amendment. See you in the next video.